Ladies and gentlemen, please take your seats. Can I invite everyone to please find your seats so that we can begin our proceedings? I've been informed, as you can see, this Feinberg Auditorium is filled to standing room capacity, and there is not just one, but two overflow rooms. I feel like I should wish you all a Shana Tova. It is indeed a wonderful start for all of us, and we are delighted. Let me simply start the ball rolling by introducing the Chancellor of the Jewish Theological Seminary, Arnold Eisen.
Thank you. It's my pleasure to welcome you to JTS for the Bernard G. Siegel Memorial Lecture in Law and Ethics. I want to extend a warm greeting to many people, first of all to those in this auditorium, and also to the many of our overflow crowds in the simulcast rooms at other parts of JTS. The tremendous, overwhelming attendance this evening, I think, is testimony to the interest and pleasure and honor we all feel to be joined at JTS by tonight's speaker, Associate Justice of the U.S. Supreme Court, Stephen G. Breyer. The annual memorial lecture was established by JTS in honor of the late Bernard G. Siegel, a longtime partner in the law firm of Schneider, Harrison, Siegel, and Lewis, and a distinguished philanthropist, community leader. Mr. Siegel was the first Jewish president of the American Bar Association, carried out special assignments for Presidents Eisenhower, Kennedy, Johnson, and Nixon, and worked tirelessly to extend the influence of the organized bar in matters of legal policy nationwide. He was recognized for his indefatigable efforts to expand and improve legal services for the poor, the powerless, and the dispossessed. I am pleased to acknowledge the presence here this evening of Mr. Siegel's grandson, Mr. Mark Cohen. Mark, where are you? Mark. I'm also very pleased to recognize the presence of Mr. Ralph Snyder and Mr. Bruce Rosenfield, former law partners of Bernard Siegel, and to thank them for helping to bring this program to fruition. Thank you. As you've just seen, tonight's program is ably moderated and co-sponsored by the Louis Finkelstein Institute and its distinguished head, Professor Bert Vysotsky, who, I'm happy to say, was recently named the Lou Stein Director of the Finkelstein Institute. Lou Stein, for those of you who remember him, was a very close friend of Louis Finkelstein and established the Finkelstein Institute in his honor. Bert is a professor of Midrash and Interreligious Studies who bears the Appelman Chair in that subject, and he is also the director of the newly formed Milstein Center for Interreligious Dialogue at JTS. Bert, thank you. Tonight's program is co-hosted by our wonderful neighbor, Columbia Law School, and I'm pleased that the law school's dean, David Schizzer, is with us this evening. David, where are you? Let's acknowledge David. I want to take the opportunity to welcome the large number of Columbia Law School students and faculty who are attending tonight's program. In a few moments, it's going to be my pleasure to introduce this evening's moderator, who will introduce Justice Breyer, Professor Ariella Dubler of Columbia Law School. Ariella is the George Wellwood Murray Professor of Legal History at Columbia Law School, where she teaches courses in constitutional law and family law, and she's the chair of the board of Machon Hadar, is a member of the boards of the Abraham Joshua Hesser School and of Moving Traditions. But before I introduce Ariella to introduce Justice Breyer, let me say a few words about why it is so fitting that the Finkelstein Institute hosts Justice Breyer this evening and why he comes in a relatively long line of Supreme Court justices who have appeared at JTS over the years. Justice Earl Warren spoke here, and Justice William Brennan, Justices Antonin Scalia and Ruth Bader Ginsburg, And if I can add one more to that distinguished list, several years ago, we had the opportunity of hearing from the former Chief Justice of the Supreme Court of the State of Israel, Aaron Barak. There's a long tradition connecting JTS intimately to the study of law. To the study of law, I might add, to the practice of law, to the interpretation of law, for two reasons. Number one, this is a place of Torah. And Torah is concerned centrally with law. The exodus from Egypt that we're reading about these weeks leads to Sinai, and Sinai leads immediately to Mishpatim, which at Columbia these days would be taught as civil law, criminal law, and torts. What do you do when ox gores an ox? How do you distinguish manslaughter from intentional homicide? How do you sentence robberies that take place during the day from robberies that take place at night, et cetera, et cetera? Law helps bring justice to the world. God wants justice. One might say, without going too far, that in Jewish tradition, ethics becomes serious when ethics becomes law. Detailed practice, not just principled, but day-to-day realities that are put into practice, that are made real. I was reminded earlier this week of why this connection between JTS and law is so intimate and so deep-seated. When I was reading the introduction written about 50 years ago by then-Chancellor Louis Finkelstein to a new edition of a great work written by the founding Chancellor of JTS, Solomon Schechter, at the turn of the 20th century. Schechter and Finkelstein were keen to transmit the rabbinic conviction that study of Torah, and particularly study of law, was a means of heightening our moral perceptions as human beings. It increased our knowledge of and commitment to the good with a capital G. Study of Torah in this view helps us understand God's will for the world. God wants greater justice, God wants greater compassion, and we enact that justice and compassion as God's creatures for all the rest of God's creatures, doing God's will by means of law. That's why the rabbis pictured God studying Torah, law, in the academy on high all day long. It's why Finkelstein would write that the Torah is at once perfect and perpetually incomplete. The law, he says, is created to be a process rather than a system. It's a method of inquiry into the right rather than a codified collection of answers. To discover possible situations with which the law might deal and to analyze their moral implications in the light of Torah's teachings, this, he said, is to share the labor of God. History changes, you see, and God wants Torah applied here and now, not only there and then. Evolving characteristics of law have been crucial to JTS's approach from day one. And if I could just conclude with one more sentence or two from Finkelstein, which bear direct relationship to Justice Breyer's topic this evening. Quote, "Joy in the law is therefore more than joy in the fulfillment of the commandments. It is also joy in the discovery of new ones, new commandments, relating to situations never before explicitly formulated. This is indeed a great privilege, one which unites students of Torah with justices of the United States Supreme Court. We are privileged this evening to hear from one of the greatest and most thoughtful ones, and in order to introduce him, it's my pleasure now to call to the podium Professor Ariella Dubler of Columbia University. Thank you all for being here.
Thank you, Chancellor Eisen. And let me just start more generally by thanking both Chancellor Eisen and Dean David Shizer for co-sponsoring this event. It's a real pleasure for me to be here under the joint auspices of these two institutions, which really play an extremely vital role in my daily life as both a law professor and as an engaged member of the Jewish community. I should also say, as Chancellor Eisen, I think, just really suggested, that these are two institutions that I think are at the forefront in very different ways of thinking about the really hard confrontations between law and modern society, which is, I think, what we're going to hear about tonight. Questions about how to make foundational texts of all different sorts speak honestly and practically to the most contentious issues facing us all in the world today. I also just want to take one moment to thank Rabbi Bert Vysotsky for organizing this event, and in particular for inviting me to introduce Justice Breyer. So thank you. Okay, to my main responsibility. It is my privilege to introduce our speaker, who really needs no introduction, but we'll get one anyway. It is a singular honor to introduce Justice Stephen Breyer. It's hard to know where to begin. Justice Breyer was appointed to the Supreme Court by President Bill Clinton in 1994 after serving for 14 years on the Federal Court of Appeals in Boston. Prior to becoming a justice on the Supreme Court, he was also a professor at Harvard Law School, a member of the Judicial Conference of the United States, a member of the United States Sentencing Commission, and these are really just the quickest of highlights. When I teach constitutional law to first-year Columbia law students, Justice Breyer's opinions and his dissents provide some of the greatest moments in my class, moments of inspiration, and from my perspective, moments of really deep optimism. They provide the moments when I can offer to my students a vision of the Constitution, not as some rigid or distant or ossified legal text, but rather as a flexible and workable basis for our government and for our legal order. And likewise, his opinions offer a really inspiring vision of the Supreme Court as deeply, deeply engaged with the real world and deeply attuned to the practical consequences of its decisions. As a member of the Supreme Court, Justice Breyer has developed this powerful, pragmatic jurisprudence. He has developed a jurisprudence that emphasizes that the Constitution is at once situated in history and, equally importantly, adaptable, and thus capable of guiding our contemporary society. So it is a tremendous privilege to have him here tonight to talk about these issues. Quickly, before I actually introduce him and turn over the podium, I just want to explain, I think people have received cards on their chairs in whatever room you're in. Excellent. The point of the cards is for you to write questions that will be collected after Justice Breyer's talk and handed up to me, and that I will, in some manner, at the end, they will be collected by ushers, brought to Rabbi Vysotsky, who will hand them to me, and I will, in some manner, try to sort them out. And Justice Breyer has graciously agreed to a question and answer session after his talk. So that's what the cards are for. With that, I would ask anyone who has not turned off their cell phone to do so. And it is now my greatest pleasure and privilege to give you Justice Stephen Breyer.
Thank you very much. Thank you. Thank you very much. Thank you. Thank you. Thank you, Ariel. That was a very, very nice introduction. And thank you for the introductions to the introduction. You're also very nice. And I'm going to be here, and I'm not going to talk too long. You know the story of the little boy who goes into temple or sees the rabbi, puts down his watch like that and says, "What does that mean, Daddy?" And his father says, "Nothing, absolutely." But I'll try. I mean, I'm going to talk about a book I've written. I mean, writing a book. A friend of mine who's an archaeologist said they discovered, I don't think this is true, but they discovered tablets 10,000 years old in Ur. And when translated, they said, things are really going to pot. The buses don't run on time. Children do not obey their parents. And every man is writing a book. That was it. But in any case, why write this book? I mean, I've been talking about it. I've even talked about it on television. And when people say on television, I guess you're here because you want to talk about your book, I say, no, you don't understand. I wrote the book so I could be on television. and there is something to that, because I have a point. And my point is that I'm trying to get across a message, and the message is to people who aren't necessarily judges or lawyers or even law students. I mean, there are, contrary to popular belief, 308 million people in the United States who are not lawyers. And I want them to understand something about the court, and I have a motive. If they don't understand something about the court and about law, they won't support it. And they don't have to support individual decisions, but they do have to support the institution. And they won't do it unless they understand it. And if they don't, I mean, we can't exist, because it is a democracy. And yet we're an undemocratic institution. So I put the problem that I'm trying to grapple with in this way. Suppose I get the attention of a man or a woman, not a lawyer, who is going into a supermarket. Now, she's busy, 2 jobs, several children, trying to get something for dinner, bills up to here. And suddenly she sees me, a judge, or somebody coming up, wants to spend an hour or so talking to, please, I'd like to hear you very much, but not now. All right, you see, that's the reaction. But can I get that person's attention? And if I do get attention, what can I say in 20 or 30 minutes that might make a difference? And maybe even they'll spend some time thinking about it. Now, that is the sort of what I'd call the object, and figure out what to say so they'll understand better. After all, we live in a period when people are awfully cynical about government. And if they're too cynical, they won't participate. And if they're too cynical and don't participate, we won't have a government. So it's an important task, just not that easy to carry out. And I'm trying to do a bit, and I have no, I obviously have no more obligation to do it than anybody else. Everybody's welcome. Everybody's welcome. I try to pass this message down, that we all know it. I mean, we all know something about government. But anyway, I put it in the form of a couple of questions because I think the questions are amusing or interesting, and that might attract some attention. What questions? First question is this. I mean, let's go back. To get the question, I have to go back into history. And the question is going to be, why do we judges have the power to look at this document? If I have it here, yes, there it is. And I look at this document, the Constitution, and decide what it means, and have other people do what we say. I mean, that's a sort of interesting question. We're not elected, and yet this is a democracy. And if you want to see who grappled with that question and how, initially, in the most important way, read Federalist Number 78, written by Hamilton. And Hamilton says, why, in heaven's name, what should we do with this document? I mean, question. Should somebody have the last word in interpreting it? Someone in the government. He says, suppose the answer is no. He says, well, I've just helped write a beautiful document, and he has. It's fabulous. Fabulous document. And they were rightly proud of it. But if he said nobody has the last word and everybody's free to interpret it any way he wants, well, let's hang it up in a museum. I mean, let's put it in the National Gallery. I mean, actually, he didn't say that because there was no National Gallery. But you get the idea. He says somebody has to have the last word. Now, who? He says, well, the president? He says, the trouble giving this power to the president is the president's already too powerful, he thinks. And the president will just decide everything in his own favor. No, that's out. Then he says, well, what about Congress? This is a democracy. Why not give them the power? And then after thinking about it, he says, now wait. This document gives precisely the same rights to the least popular person in the United States as it gives to the most popular person. Congress. Well, Congress, he says, they are experts in popularity. I mean, believe me, they know popularity. Now, if they didn't know popularity, they wouldn't be in the jobs that they're in. And can we trust them to follow the document when doing so is very unpopular, considering a law they just passed because it was popular, then holding it unconstitutional for doing so is unpopular? He thinks, well, I'm not sure. I'm not sure. So quite honestly, the impression it'll give you is he thinks of the judges just because he couldn't think of anybody else. He says, we have over here a group of people, judges. This is sort of a legal job. They're kind of gray. They're sort of, nobody's ever heard of them. This is great. And they don't have the power of the purse, and they don't have the power of the sword. Wonderful. They're weak. They won't go too far. Anonymous, legal job, no purse, no sword, That's the best we can do. Give them the job. And it's that theory that in Marbury versus Madison, John Marshall wrote into the Constitution. He didn't make it up. It was all over there in the Constitutional Convention. You read Gordon Wood's history of that time, and you will see. It wasn't, I mean, Marshall implemented it, but it was well accepted, well accepted. All right? Now, that brings me to the question. The question is this, and it's one very important question that Hamilton just does not answer, because he can't, because he doesn't know the answer. And the question is this. Well, if these people, the judges, are so weak, anonymous, no purse, no sword, and they are going to decide things that are pretty unpopular some of the time, and indeed they might be wrong too, after all, they are human beings. And wrong, unpopular, I mean, important, weak, why will anyone do what they say? I mean, that's a question. It's Hotspur's question in Henry IV. You know, Owen Glendower comes in, he's a Welshman, so he's a mystic. All Welshmen in Shakespeare are mystics. And Owen Glendower says, I can summon demons from the vasty, spirits from the vasty deep. And your practical Englishman, Hotspur, says, well, so can I, so can any man, but will they come when you do call for them? Well, that's the question. And if you think that's somehow a dated question, you haven't been sitting in my office. I know you haven't been sitting in my office, but still, if you were, you would see. I talked to some groups from Tunisia yesterday, some students. They had that question, why does the president do what the court says? And they had something in mind there, you say. And I got the same question exactly from a woman who is the Chief Justice of Ghana. And they're trying to make all kinds of changes, very important ones in Ghana too, democracy, protecting basic liberty. And when we got down to discussion, what she really wanted to know is why do people in the United States follow what you say? And how do I answer that? I talk about the document. It's a wonderful document, you know, right level of abstraction, very intelligently put together, etc. But I said, really, that isn't the answer. I mean, that is an answer, but not the answer. And I can't answer your question without telling you a little history. And so if I have 5 or 10 minutes, I'll take a little history. And I'll tell you, as I told her, or I tell the students in Tunisia, about 2 or 3 cases that I think illustrate certain points of our history that are relevant to this question. I mean, first I like to go back to the Cherokee Indians in 1834-35. It's a wonderful case. The Cherokee Indians lived in northern Georgia. They owned northern Georgia. There were treaties. There were laws. It was theirs. And they had an alphabet. They had schools. They had a constitution. They did farming. They'd given up hunting and fishing, the ones who lived there. And they had one other thing which really got them into trouble. They found gold. Yeah, because the Georgians said, we don't see why Indians should have gold. We should have gold. I mean, after all, we're Georgians. They're Indians. Goodbye gold. Goodbye Indians, rather. And they went in and took the gold. Well, I mean, the land belonged to the Indians. So the Indians, to make a long story short, did what any civilized group of people would do. They hired a lawyer. And he was a great lawyer. He was a great lawyer. Willard Ward, he was the greatest lawyer of his day, been Attorney General of the United States, and he represented them. And after a lot of maneuvering, he finally got the case to the Supreme Court in a posture where they had to decide it. And when that happened, they decided it. And they decided it in favor of the Indians. And they said, this isn't a very close question. That territory belongs to the Indians, not to the Georgians. And you may have heard of that case because that is the case about which President Andrew Jackson supposedly said, John Marshall has made his decision, now let him enforce it. And Jackson sent troops to northern Georgia, but not to enforce the decision of the Supreme Court, rather ultimately to evict the Indians. And the Indians were evicted. They traveled the Trail of Tears to Oklahoma, where their descendants live to this day. Trail of Tears because so many died along the way. Well, I mean, that wasn't a happy augur for what the role of the court is going to be. Okay? It's not. But time went on. Time went on. And not all the cases were like that. But the court was very hesitant about saying things were unconstitutional. And you can see why. I mean, Marshall was in Marbury versus Madison. Marshall worked out a way of saying a law was unconstitutional, but he, in fact, arranged this case in such a way that his sort of archenemy in this area, Thomas Jefferson, the president, was going to win. So Jefferson, well, I'll spare you that. You have to go back to first-year constitutional law. And if you've never taken first-year constitutional law because you're not a lawyer, at Columbia they love auditors, so why not everybody? That's it. But the point is you've got it. I mean, it isn't certain whether people will, including presidents, follow what the Supreme Court says. But let's roll the cameras forward, in a sense, and go to a case I like much better. Cooper versus Aaron, 1957-58, Little Rock. I mean, some of us remember that. 1954, Brown versus Board of Education. Finally, the court says, look, it says here, no state shall deprive any person of equal protection of the laws. That's what the 14th Amendment said. And living at that time, as some of us did, if you wanted to know whether there was equal protection of the laws in the South, you opened your eyes and you looked. I mean, it wasn't really very tough to figure out the answer to that question, which was completely no. And the court said, no, these words mean what they say. You cannot have legal segregation. That was Brown. The schools will be integrated. That was Brown. That was 1954. And what happened in 1955? Yeah, you're right, nothing. I mean, not much. And what happened in 1956? Yeah, you're right again. Double nothing. But 1957, a moderate school board in Little Rock began to get interested in this, and they worked out a plan, and they were in the September of 1957 going to take the Little Rock nine very brave black students who would be integrated into Central High, an all-white high school. But during the summer of 1957, Governor Faubus, who had been a moderate initially, began to be persuaded it was somewhat more popular not to be so moderate, and the governor of Georgia came into Arkansas and said, I don't know why you have to integrate. He said, we don't integrate in Georgia. Very nice remark. And the result of that was that more and more opposition began to arise until that first week of September when those 9 children walked out there and began to go to the school. No, there were white citizens council members, there were people all over in front of the school determined to stop that integration, and Faubus had given the order to the state police that you'll keep the black kids out of the school, not let them in. And that was quite a period of 2 or 3 days. Some of us remember the picture of Elizabeth Eckford, black girl, been turned away by the police. And she's walking away with her books back towards the bus stop. And behind her is a white woman, her face absolutely contorted with rage. It's Hazel Bryant. Interesting book recently written about those two, very interesting. But in any case, at that time, that picture went around the world. And it did not present a happy picture of what the United States was like. So what to do? Well, Brooks Hayes, who was the moderate congressman from Little Rock, got a hold of President Eisenhower and Governor Faubus, and they agreed that Eisenhower agreed to meet with Faubus he was in Newport in the summer White House, and Governor Faubus went up there and went in to see Eisenhower, and after he said, the general dressed me down, he said, like a general dresses down a sergeant. And he told Eisenhower that he would allow the school to be integrated. And he walked out of the room and told the press the opposite. Now, Eisenhower wasn't very happy. And then he had to figure out what to do. I mean, and he got conflicting advice. Jimmy Burns, who was, some of you remember that name, he'd been a member of the Supreme Court of the United States. He resigned in World War II in order to run the domestic part of our mobilization effort. He was then governor of South Carolina. He was a moderate on race. He was a very good friend of President Truman. And he went to see Eisenhower, and he said to President Eisenhower, well, if you send troops into Little Rock, he said, you better be prepared to reoccupy the entire South. He said, are you ready for a second Reconstruction? The best that will happen is they'll close all the schools, and nobody will be educated. But Herbert Brownell, who was Eisenhower's wise counselor, said, you've got to do this. You've got to do something. You cannot allow this defiance of the law in America. You've got to enforce the board's order. And Eisenhower said he would. He would do it, and within 2 or 3 days, he was on the radio, and he said, I have ordered 1,000 troops, the 101st Airborne Division. And he was a good politician, President Eisenhower, and he knew what those words, 101st Airborne, meant to every American in 1957. I mean, these were the heroes of the Battle of the Bulge. They were the ones who parachuted into Normandy, and we had pictures of them being hung up on those steeples as they parachuted down at D-Day and shot down by the Germans. So they were heroes to every American. And 1,000 of them were taken on planes, brought to Little Rock, and the next day they took those 9 black children and walked with them into that white school. And pictures were taken. And those pictures went around the world. And when I think of that, I still get a kind of shiver. I mean, that was a great day. That was a great day for the rule of law in America. It was a great day for the cause of equality. It was a great day for the United States of America. Now, I wish I could end it at that point. Unfortunately, I can't, because the troops had to go home eventually, and they were still in the school. And read some of the stories. That wasn't a very pleasant year for anybody, and particularly not for those 9 children. And a segregationist board was elected, and the segregationist board said, no, we don't want them there anymore. And they got a lower order court order that maybe they didn't have to, and that was appealed all the way to the Supreme Court. And in 1958, in a special summer session, really the court heard that was the case of Cooper versus Aaron. And the court, 9-0. Indeed, all 9 judges signed the opinion. Very unusual. Integrate now. Integrate. Don't withdraw. You can't do it. We meant it. Every one of us is behind Brown versus Board, and you really have to do it. So do it. And 9 judges said, wait, they were 9 judges? They were 9 judges. There could have been 90 judges, 900 judges, maybe even 9,000. The day after the Supreme Court said, go ahead and integrate, Governor Faubus closed the schools. And no one was educated. Yeah, it's a more mixed story than you might think. You see, but to me, still, that was the beginning. That was a catalyst. We had then Martin Luther King, the Freedom Marches. They couldn't keep it closed. Within a few months after that, they had to reopen it. Read the stories of the people. Sports Illustrated actually had a very good one about that Little Rock High football team that year. They missed their education. Their lives, some of them, were really changed for the worse. But something was going on, and that was part of it. And we can remember, too, the Freedom Riders, and we can remember what was going on in the South at that time. And you could say, well, did President Eisenhower's enforcement of a rule of law and an order of a judge, those 9 signing it, have anything to do with the progress that was then made? Yes. In my opinion, of course, I'm a judge. I mean, I'm prejudiced. But for me, that was a catalyst. That was a magic moment in American life. That was a magic moment that produced good. And of course, it couldn't have been done without the help of all kinds of other people, without the Freedom Riders and so forth. But it was done. It was done. And it was a struggle. And it didn't happen in a day, and it didn't happen in a month, and it didn't happen in a year, or even 2 or 3. But it did finally happen that legal apparatus of racial segregation was dismantled. And so I hope maybe some of you will think with me that the 1,000 troops, the enforcement of the court order, yeah, it had something to do with it. And when I had to, one time I had to take around the court a Russian parachute general. So he had been in charge of pointing the missiles at the United States, and they changed direction. So the State Department called up and said, we should be nice to this man. So he came to the court, and I, showing him around, we're talking about cases, said, what are some of the cases you like? I told him this story. And he said, oh, I said, the moral of this story is the paratroopers and the judges must be friends. Think about it. You want a third case, take whichever one you want. When I'm talking to usually a group of law students, I'll say, take the one you like the least. Which ones do you really hate? Which ones do you really hate? I mean, abortion, some. Prayer in schools. What about Bush v. Gore? That's a good one. I mean, I said, let's think about that one. That was certainly important, wasn't it? Yes, it was important. And it was unpopular, at least with half the country. And I was in dissent, so I think it was wrong. Okay? Well, but the point that I want to make about that is the point that I heard Senator Harry Reid make. And I don't think he disagrees with the merits. I mean, you know, he's with me probably on that, I guess. But look, he said the most remarkable thing about that case is that something that's very rarely remarked, and that is that even though very important, pretty unpopular, and wrong, okay, people followed it. There were not guns. There were not bricks, riots in the streets, stones thrown, and people killed. So when I say that to the students, I then will say, you know, I know you're thinking, too bad there weren't a few, I know. I said, but before you come to that conclusion, definitely, you turn on the television set and you see what happens in countries that decide their major difficulties and problems in the streets with guns or weapons rather than in a court of law. And that's what I'm trying to communicate. The thing that gives me a thrill sitting where I do sit in the court, and it has for the first day, and it does not change, that you see in front of you there looking out, you see people of every race, every religion, every point of view. And the point of view, I mean, my mother used to say that. She said, there's no view so crazy there isn't somebody in this country who doesn't hold it. We lived in San Francisco. She said they all live in Los Angeles. But the point is made. I mean, that is the thrill. They will do it. We will do it. I mean, Americans will do it. And that's a treasure. All right, that's one of the things I'm trying to communicate. And it's really not talking to other judges. It's not talking even to other lawyers. I mean, it's really teachers, communities. They're the ones that have to explain it. And they have to explain it like having civics classes where somebody learns about what government's about. I mean, what is this government? What is civics? Where has it gone in so many states? And so forth. And I just simply want to, you know, I'm trying to motivate people and say, I have no greater responsibility here than anybody else. I mean, we're trying to pass something down to our children and our grandchildren and so forth. You get the point. Now, I'll be briefer on the second point. But the second point's related because I don't want to, I say, look, the people who have to do this, if it's going to be done, are really people in communities. They really are school boards. They really are teachers. They really are all those people who might talk to all those people and get them motivated about encouraging these people, namely the students and the next generations, to understand the government enough to know that they have to participate and so forth. That's something for all of us. But I can't say the court's free of special responsibility. So I said, well, what about us on the court? And here I'm more limiting it. Don't we have some responsibility here? And I say our responsibility is getting these cases decided correctly. Well, I say, of course, everybody say, yeah, at that level, yeah, we agree with that, no problem with that. But what is to decide them correctly? What is it? What is the nature of this job in really difficult cases? They're all pretty difficult. We only take cases, or almost only, because different good judges at lower levels have come to different conclusions on the same question of federal law, Congress or the Constitution. So none of them are easy, but some are probably more important in the public mind than others. And when they're really tough, well, how do you decide them? How should you decide them? And we don't all agree about that. How should you decide them? Do you? And again, if I'm talking to my friends, the law students, I know what you're thinking. I know you're very polite, you won't say it, but you're thinking that the real way we decide these cases is called politics. That's what it is. You are junior grade politicians. And I say, no, we're not. They said, well, sure you'd say that. No, and I said, but look, if that's what we're doing, Hamilton was wrong. If that's what we're doing, there was no reason to give this job to us. Give it to Congress. At least they know how to be politicians. I mean, please, if you want to think that judges know something, they all think every judge thinks he knows a lot about politics because he was once confirmed by somebody. All right? So, but no. I mean, if you want the best example of that, go read the Dred Scott decision, probably the worst ever decided in the Supreme Court, where the Supreme Court of the United States said that a descendant of a slave is not and cannot be an American citizen. I mean, there's no go through that. I talk about it in this thing I've written, but really pretty bad decision. I mean, terrible. And the only justification I've seen for it is that Roger Taney, the Chief Justice, and those who were with him in deciding this thought that maybe by doing so they would stop the Civil War, a political reason. But if that's what they thought, they really started the Civil War. I mean, there's a better argument they started it than they stopped it, because it was such an outrageous decision that the dissent written by Benjamin Curtis was picked up by Abraham Lincoln, used as the basis for his Cooper Union speech here in New York, the dissent, and said, you know, the court's totally out of control. And Lincoln, as a result of that Cooper Union speech, elevated himself in the party and moved them towards a more abolitionist, it wasn't totally abolitionist, but a more abolitionist point of view. His party and he were elected, hence, and you all know what happened. But anyway, if it was a political basis, that decision, they certainly got that one wrong. I think judges are bad politicians. They shouldn't be, and they aren't. They're no good at it. And it isn't the job. You say, well, all right, well then what is it? What is it? What is the job? I mean, I grant you people have different philosophies of law. That's a different matter. That isn't politics. Ah, now you're onto something. Different philosophies of law. Different basic approaches towards the job of deciding difficult legal questions. What about that one? Not politics, but we have one. Some of my colleagues think this. Colleagues who are good friends of mine, and we discuss it very directly. Justice Scalia thinks that the answer to this will lie in history, originalism. Look to see what the founders would have thought about the answer to this particular question. Do as much as you can there. And I'll say, we've discussed this. We discuss this publicly a lot. It's pretty, I found it interesting. I learned something. And it's useful for me. And you say, well, yeah. He said, why? Because he wants to keep just what you're worried about. He wants to keep under control the judge's subjective influence. He wants to keep under control. I'm not there to do what I think is good. I'm not in this job where I have power to affect other people's lives, simply to write into the law anything I think is a good thing. If that's what I'm doing, it's not the right thing for me to do. And if you have 900 judges in the United States, or 9,000, or even 9 on the Supreme Court, and you tell everybody just write into law whatever you think is good, you will see the mess that ensues. Because people think different things are good. And they have different ideas about that. So, now, can't be that either. Can't be politics. It can't be just writing what you think is good into the Constitution of the United States. Well, what about this history? And what he'll say, it's a good way of keeping that second thing or the first thing in check. We have something objective here. And I'll say, well, you know, I mean, history, I mean, yeah, I mean, something, you have to find out the values that are there by looking at history. You have to find out what this provision meant. We know what the words abridge the freedom of speech. You have to have an idea of what underlies that. But I mean, George Washington, you know, George Washington did not know about the internet. To which he says, oh, that's a brilliant point. He says, I didn't know that. But you see, he does know that, of course. And he says, isn't it? He says, well, he responds to that rather bad joke with a rather good joke. And his joke is this. He says, it's a pretty good one. He says, it's the two campers. The two campers are out there, and one of them is putting on some running shoes, and the second one says, "What are you doing?" He says, "Well, there's a bear coming." And the first, "You can't outrun a bear." He says, "Yeah, but I can outrun you." You see, that's his point. Doesn't say this history thing is perfect. He says, well, but it's better than the alternatives of just subjective doing whatever you want, or depending upon politics, or something else. He says you can't fight something with nothing. Now, that's the challenge of the second part of the book. Because if I'm serious, I'm not going to have a theory, but I can at least have an approach. I can at least say judges whom I in the past admired, Brandeis, Holmes, Cardozo, Hand, they had an approach. Good, what? Well, I found a very good statement of it in Gordon Wood's book about the Constitutional Convention, about that period of time, where a judge in Connecticut in around 1790 said that the American system of interpretation, appellate judging, he says, can be characterized as prudent, pragmatic, reasonable results, and utility. All right? So I said, what about? He says, well, that's awfully abstract. I mean, that sounds like a 4th of July speech. I mean, that sounds a little bit like bumper stickers. I said, well, I can do better than that. I can do better than that. I can take those ideas and I can say, let's look, develop them a little bit, and consider the following. That the problem in most difficult cases, is not the problem of figuring out what the framers meant. The problem is taking the values that are there in the document, and we know that's what they meant. They meant to encapsulate in the freedom of speech a certain kind of freedom of expression. The problem is not working out what they thought about that as much as it is taking what you know they did think about that and then applying it to changing circumstance. You're taking a value that doesn't really change, or at least not much, and you're applying it to circumstances that change every day of the week. Well, all right, that's the task. But in doing that, what do we have as tools? We have first certain basic values in the document. Like what? Well, I think that most of us who read this document will say, I can summarize it. I can summarize it not totally in bumper stickers either. But if you look at the document, it is a document that first creates democratic political institutions. That's the first 7 articles. They've come to be very democratic. And that means that almost all decisions about what kind of towns, cities, states, communities we're going to have will be made by the people through the ballot box. But it isn't just democracy. It's a certain kind of democracy. It's a democracy that protects certain basic fundamental human rights, those are the 10 amendments, that divides power vertically, state, federal, horizontally, 3 branches, executive, legislative, judicial. Why? So that no group of people become too powerful. Those who are in the government, pockets of power, spread around, a recipe for total inefficiency, but an inefficiency that we think is worth the price, because that's the price that we pay for preventing some group of people becoming too powerful. And you can't have it both ways. And therefore, that separation division of power errs on the side of protecting the people from too much concentration of power. But it's there. Fourth, a certain degree of equality. That's the 14th Amendment. Equal respect for individuals by the law. And the rule of law itself. All right, so I get 5 things. I say I got 5 basic things, and I see quite a lot of the rest of it as elaborations on that point. All right, that's one thing, basic values, and you can find values in the details as well. Second, highly purposive approach towards deciding cases. You have a statute. What's the object of it? Somebody wrote those words. What's the basic value or object? What is the basic value underlying freedom of expression? What's the basic object, even in the most technical statute? What is the basic object of these words? Highly purposive, value-based, highly purposive. I would say cooperative. The document as a whole is a document that does divide power among different branches and different institutions, but it is also a document that has to work, and so there have to be ways for these institutions to cooperate with each other. And then a certain degree of pragmatism. What do I mean by pragmatism? I mean, in case after case that we don't have right versus wrong, we have right versus right. We have a case where, on the one hand, to decide this way will protect liberty of expression, but will hurt privacy. To decide the other way will, in fact, help people maintain personal privacy, but will hurt liberty of expression. That's the typical kind of case, where you have right versus right, not wrong versus wrong, and what you're trying to do is work it out. And I say pragmatism, looking at consequences, is what's important there. All right, now, the last 10 minutes or 7 or so has been pretty abstract. So the only way to get this point across, and that's what I'll try to do, I can't do it very much here, but I do that when I'm writing about it, is to give you an example, an absolute example, interesting example. Because I can go through, when I'm writing in this book, and talk about the relationship of the court to Congress, the relationship of the court to the bureaucracy, the relationship of the court to the states, the relationship of the present court to past courts, the relationship of the Supreme Court to lower courts, but one of the most interesting ones is the relationship of the court to the president. And I'll give you an example of the tension, the real tension that can exist, and how it's important to allow cooperation without just giving up and saying one or the other branch can do whatever it wants. Where is that tension the greatest? I think the greatest is when the president is exercising his power to keep the nation secure. His power to keep the nation secure in time of war or national emergency. His power supplemented by Congress's power to do just that. And that has nothing to do with the courts. Well, that's his power, and that's Congress's. But suppose in exercising that power, he limits traditional civil liberties. At that point, the courts are involved, because the courts do have primary authority, not complete authority, but certainly a primary authority to protect individual liberty. And what happens when they clash? I'll give you 2 examples in 7 minutes. And that's all. First example, to show you the problem. When I grew up, at the time I grew up, 1942, I was alive. 70,000 Americans of Japanese origin in the spring of 1942 were removed forcibly, against their will, from the west coast of California and put in camps in eastern California in the Intermountain region. I mean, that happened because the head of the General DeWitt, who was head of the 6th Military, was afraid of an invasion from Japan. And he said, we better move all the Japanese out, because I have incidents, 735 incidents where they were communicating, or someone was, with submarines, and several instances of sabotage, and the only thing to do is move them out. And they went to camps and stayed there. People were worried in California. But people, by the way, who wanted, Earl Warren wanted them moved. He later said it was the worst thing he'd ever done. Main opponent who wanted them to stay, J. Edgar Hoover. He said, there's no need. The FBI has this under control. But they were moved, and finally, a few people, most of the families, didn't want to bring lawsuits. They just wanted to keep a low profile. But Fred Korematsu wanted to bring a lawsuit. I met Fred Korematsu through an amazing coincidence. My next-door neighbor in Cambridge is the daughter of a man named Ernie Bezig, who was head of the ACLU in San Francisco, used to play poker with my father. And his daughter moves next door to us in Cambridge, and one day she calls up and says, I have somebody you'd like to meet. I go in the living room, there's Fred Korematsu. And he was great. I mean, a very feisty guy. I could see why. He was 80 years old at that time. And he's going to bring this case. He says, this is America. They can't do this to me. And Besig represented him. The ACLU initially wouldn't. Very interesting. We're at the beginning of World War II. The ACLU came in later. They came in later. But it took a doing. Well, anyway, Besig was Korematsu was certain he was going to win that case. And so was Besig. They got to the Supreme Court in 1944. They finally get, well, there's no danger of Japanese invasion in 1944. You know, none. And they're sitting there in these camps. And Korematsu said, Besig and the others, they had a very good case presented. They said, this is ridiculous keeping us here. It's illegal. It's against the Constitution. And the Justice Department at that time, there were two lawyers, Ennis and Burling, and they got awfully suspicious of what the Army had been saying. They call in the FCC, the Communications Commission, and said, look up those instances. Will you look up those instances of signaling that were supposed to have taken place in early 1942? Tell us about them. And the same with sabotage for the FBI. 2 weeks later, the FCC people come in with huge files. And they say, there wasn't one. We've looked into every single one. There wasn't one. These incidents are really buck privates, didn't know how to work the equipment, or something the equivalent. Not one. And the FBI said the same thing about the sabotage. So Burling or Ennis says to him, he said, gee, that was amazing, I said, you found. But how did you do it so quickly in 2 weeks? Oh, we didn't do it in the last 2 weeks. This was all done at the time. And we showed it to General DeWitt. Yeah. So they go and they say, we're not signing this brief. At that point, they send the brief over to the War Department at a fit. You've got to do this. You've got to do it. And it was put, I say that because you're at Columbia. Guess who was the Assistant Attorney General? This name will mean only something to a few people. Alice Henkin, for example, will. Who was the Attorney General in charge of war that mediated this little internal dispute? Herbert J. Wexler. Well, he wrote a footnote that he got these two lawyers to sign on to and put in the brief, and believe me, no one could understand what that footnote said. Or well, that not quite, but almost. So they agree to this very impossible footnote. It gets up there, but I was rather interested, and I read the oral argument, and Charlie Horsky, who was representing the Japanese-American Defense League, asks the justices, read that footnote. He says, read it till you understand it, and you will see there is nothing to the government's case, and they admit it. And if you read now what happened, 6-3, the court upholds the removal. And the question I put to myself is, why? Why? Who wrote the opinion? Black. Who was in the majority? Douglas, Frankfurter, the liberals. Yeah. And the ones who were later for Brown. And I think, why are they doing this? And I look at the dissents, Jackson, Roberts, and Murphy. Murphy, who's perhaps best known for this dissent, I thought it was an awfully good dissent. It seemed, this is to me, somebody must have told him all those things. He was so right in what he said about what the facts were. I called up a man who was his law clerk then, who's the one who wrote the Supreme Court procedure. Oh, God. Who is it? Famous man. He wrote all the procedure books in the Supreme Court. He was the law clerk at that time. Unfortunately, he's in his 90s now, and I'm going through. So I called him up and said, did somebody tell you, I did that about a year ago. I said, did somebody tell you all these facts? We had them all in the footnotes. He says, well, to tell you the truth, I don't remember. So there we are. All right, any case. Now, why did they come out that way? Well, my own opinion, whatever it's worth reading it, I mean, they have jobs like mine, I read it, I try to read it with that kind of understanding, is they were afraid to do anything else. They reasoned this way. They said, we're at war. Even if this case, there'll be other cases. Somebody has to make these decisions. I mean, it's Roosevelt or it's us. And we know that we can't do it. Therefore, it's Roosevelt. I think they're reasoning something like that. And that case, along with Dred Scott, is generally viewed as a very bad one. You see, but indeed, I think it is. I don't think it is, but we're not at war. All right, so now what? If we think that's so bad, well, what's better? Now, here is what I want to contrast in a minute or so. We've had 4 cases come out of Guantanamo. 4. And in each of those 4, it's been the prisoner, or detainee, usually not the most popular person in the United States. I mean, one was Ben Laden's driver. I don't think he's the most popular person in the United States of America. And they're all suing, say, the President of the United States, George Bush, who is pretty powerful. And in each of those cases, the detainee won, opening up the courts to them and so forth. All right, it's not as easy as you might think, but it was done. 5-4, they're opened up. Now, you look at those cases, and we're criticized all over the place for those cases. I mean, one group says, my goodness, you've stopped the president from being able to protect us. Another group says, this is one of the flimsiest protections of civil rights you've ever seen. Why didn't you decide the hearsay issue? Why didn't you decide this? Why didn't you decide how far it should go and beyond Guantanamo and what happens if they bring them to Europe and so forth? Now, why do I sort of overstate that a little bit, not too much? Because I want you to see what I think is going on. This isn't a private thing. Read these opinions, which I put in there. There's nothing in there that isn't totally public. But as you read them, you see they're hesitant. They don't go much further, not go much further than they have to. Decide this thing here, this narrow thing here, and don't go too much further, though this person wins. And here's why. You see our reaction to Cornwallis. The challenge. The president does have to protect us, but we have to protect civil rights. All right? 2 principles that come with it. What's the moral? Be careful. Don't give up. Don't give up, but be careful. Don't give up. Don't say there is no protection. There is a protection, but be cautious in the way that you write it. Now, that's not inside information at all. That's simply a way of looking at the opinions which I print there. And you say, what's your reaction to them? And then contrast them with Guantanamo. And of course, what I'm trying to do there is to suggest there is a real challenge as to how you apply these principles in wartime, where the court is on one side and the president on the other. That's a tremendous challenge for judges. And the motivation or the theme has to be, you're not going to give up, but you're going to reflect the fact that the president is in charge and Congress are protecting the security of the United States. And it will have to be history or some other group of people that will say whether the court did or did not get it right. Now, why do I go into that? Because I'm trying to show you the difficult, really hard cases about how to apply the general, more abstract approaches that I talked about earlier. But anyway, good, the debate will rage. What is the right approach? What is the right approach to these cases? The most interesting thing about it, after the final case, where the court had said that the courts have to remain open, and the law that Congress passed, which said that the detainees cannot apply for writs of habeas corpus, that's unconstitutional, the President of the United States, who was then George Bush, said exactly, interestingly enough, what Vice President Al Gore said after the case of Bush versus Gore. In effect, the Vice President said, don't trash the court. What President Bush said? He said, I'll follow it. He said, I don't have to like it. I don't have to agree with it, but I'll follow it. And what I wonder, of course, in reading those statements is, did each of them understand the 200 years of American history underlie those two statements? Do they understand? Well, those are the things I'm trying to explain. I want to explain enough so that people will see in several different areas what the nature of the job is. I want to they should understand so that they can decide. Of course, I've decided. You have? Do they want an institution that will not be a political institution, that will be human and can make mistakes, that will sometimes do unpopular things, made up of judges who will have the last word in interpreting this document? Easy to like it when you like the result. Not so hard. When the other times, you won't always like it. And you still have to like this institution. So what's the overall motto, I guess? Well, still teach civics. But what is it you're trying to get across to people? I hope very much, what it'll get across is that women in the supermarket will think, what I want my children and my grandchildren, I want them to know something. I want them to learn something of the history of the United States of America. I want them to know what their government institutions are like. And I want them to learn and to know enough so that they will participate in those governmental institutions. Because if they don't participate in their communities, one thing I know is that the document that I interpret won't work at all. So that's what we're trying to get across. That's how I'm trying to do it. And I hope that you'll try as well.